Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have some breaking news updates in the Justin Baldoni versus Blake Lively legal saga tonight. Leslie Sloane, the publicist for Blake Lively, has filed a motion to compel against Justin Baldoni and the Wayfair parties. And we'll get into what that means in just a second. I want to wait a minute for people to filter in here before we start going over the documents. And also give a shout out to my friend. It's Kim here. Hey Kim, how's it going? Thank you for the $2 super sticker. I appreciate you. Hey Bruce, what's up? So this document, we won't be going through it word for word. It's over 100 pages. The motion to compel document is, but that includes an exhibit that was the lawsuit filed against the New York Times in California. So that's a good 88 pages of it. So we won't go through that because we've already seen it. But we have some of the questions that are being asked, like some of what Wayfair is being asked to produce. They're responding saying like, this is vague. We don't want to answer for XYZ reasons. And we're going to see what it is that they don't want to answer that Sloane wants them to answer. So, and remember, Leslie Sloane is the one who's saying like her woman-owned business was dragged into this unfairly, blah, blah, blah. We've heard that before, right? Okay. I think we got enough people in here now to start. Let me go ahead and pull it up. All right, so here we have, this is just the one-page letter, and it's regarding something that's going to be sealed, so we won't be able to see it, and I'll tell you what that is in a second. On behalf of Leslie Sloane and Vision PR, we request the court preliminarily seal Exhibit A to the Sloane party's motion to compel. Exhibit A is Justin Baldoni's responses and objections to Ms. Sloane's interrogatories, which the Wayfair parties designated confidential. The Sloane parties respectfully request that the court not rule on this letter motion to seal for 1 week, so that the parties have the opportunity to meet and confer, and the Wayfair parties may file for a motion for continued sealing if they so choose. So right now, we're not going to be able to see Exhibit A. It doesn't mean that we won't be able to see it ever. If they want to continue sealing it, they have to kind of hash this out, and they'll have to file a motion for that per the protective order. So, or at least I think that was kind of what they were getting at when they did that. So here is the actual document that we're going to be going through. It's 132 pages, but like I said, 88 of them are the lawsuit against the New York Times. So that is a little bit of saving grace for me because I get tired reading this shit. And, well, let's just say I had my nighttime medicine about 5 minutes ago because I did not realize that this was going to be coming out. So we're going to get through this before that kicks in, or we're going to have a problem. I'm going to be sitting here giggling at the camera for hours, okay? All right. Let me close that. Can you guys read that okay? I might need to zoom in a little more. Yeah, there we go. Okay. So we'll read the beginning part of this here. Dear Judge Lyman, on behalf of Leslie Sloane and Vision PR, we write pursuant to Individual Rule 4.c to request the court compel the Wayfair parties to respond to the Sloane parties' interrogatory, numbers 3, 4, 5, and 7, and produce documents responsive to request for production number 32. The parties conferred in good faith, but were unable to reach a resolution. So they've already met about this, but they haven't worked it out yet. Okay. After 4 months of dissembling and issuing vague and inconsistent statements through their attorneys, the Wayfair parties have yet to identify the basis for their claims against the Sloane parties, including but not limited to 1, the statements they claim defame them or put them in a false light, 2, when or how those statements occurred, and 3, to whom those statements were made. As set forth in the Sloane parties' motion to dismiss, the Wayfair parties were required to, but did not, provide this information in their complaints. Okay. The Wayfair parties' opposition brief provided no further specifics, stating only that they know and allege that Sloane made statements to reporters referring to Baldoni as a sexual predator and accusing him of sexual assault, and seeded false information about Baldoni to the Daily Mail in an effort to divert negative attention from Lively. The Wayfair parties somehow made these factual assertions despite previously including in their now dismissed California action against the New York Times an image capture of that Daily Mail reporter conceding to Brian Friedman and Melissa Nathan that I had many conversations with Sloane about Blake, and never once did she say anything about sexual assault. See Exhibit C. Exhibit C is that lawsuit against the New York Times that she's referring to here. Because Miss Sloane denies ever referring to Baldoni as a sexual predator or accusing him of sexual assault, she is unable to meaningfully defend herself without knowing what the Wayfarer parties accuse her of saying, and to whom. If, as it appears, the Wayfarer parties have no Rule 11 basis for their claims, they should be forced to make that admission in discovery now, rather than hide behind boilerplate objections to clearly appropriate discovery requests. Okay. We have some footnotes here. Let's see. Okay, because the Sloane party's discovery requests and the 8 Wayfarer responses are identical, Justin Baldoni's responses are attached as Exhibits A and B. Okay. So footnote 2 here is referring to that message that she was just quoting that she's saying was from their lawsuit against the Times. It says, that same message, which the Wayfarer parties have yet to produce, reveals that Melissa Nathan surreptitiously listened to Miss Sloane's phone calls in violation of California's wiretapping statute. What? What? The Daily Mail reporter writes, I had a 3-way call with her and Melissa, and she never said anything about it then either. There was, however, never a 3-way call that Miss Sloane ever knew of, meaning that either the Daily Mail reporter or Nathan added the other to a private conversation without Miss Sloane's consent. Interesting. So, I'm obviously not an expert on these things, so we're going to have to wait and see what the lawyers have to say about that footnote there. I know sometimes when skimming over documents, these things get missed, so we're going to have to ask Omar, the Tilted Lawyer, next time I can get him on a stream, or we'll ask one of these guys later. Hang on. Adrian Clark, thank you for the 5. Read fast, it's okay. We can watch it again after at the live at 80% speed. Thanks. L. Shaw, thank you for the $5 super sticker. I appreciate you. Okay. 1, the Wayfarer party should answer interrogatory number 3. Interrogatory 3 requests that the Wayfarer parties identify each person you allege the Sloane parties communicated with regarding the Wayfarer parties. The relevance of this interrogatory is obvious, given that the Wayfarer parties are asserting claims for defamation and false light based on unidentified conversations Ms. Sloane allegedly had with unidentified persons at unidentified times using unidentified words. During the meet and confer, the Wayfarer parties clarified that their sole objection to interrogatory number 3 is that it purportedly exceeds the scope of Local Civil Rule 33.3. This objection should be rejected for multiple reasons. As a threshold matter, the Wayfarer parties did not lodge a timely Rule 33.3 objection to interrogatory number 3 in their written responses and objections. Okay. Even if the objection was not waived, interrogatory number 3 falls squarely within the scope of Rule 33.3, which permits interrogatory seeking, among other things, names of witnesses with knowledge of information relevant to the subject matter of the action, and information of a similar nature. Okay. This necessarily includes the names of witnesses with information relevant to specific claims. The Sloane parties require a response so they can target future discovery requests appropriately. Absent more information, the Sloane parties are unable to assess which, if any, of the potential witnesses among the over 150 individuals and entities listed on the Wayfarer parties' initial disclosures has information relevant to the claims against the Sloane parties. 2, the Wayfarer parties should answer interrogatory numbers 4, 5, and 7. Okay. Let me see what these footnotes were. We got 3. During the meet and confer, the Sloane parties proposed narrowing interrogatory number 3 by adding the following italicized language: to the extent those communications are relevant to the claims and defenses in this action. Even with this limitation, the Wayfarer parties continued to object. And 4 says, the Wayfarer parties' only defense for their objection is their assertion that the Sloane parties also objected to interrogatories on Rule 33.3 grounds. But the interrogatories the Wayfarer parties served are substantially different from and broader than the narrow ones at issue here. Okay. The Wayfarer parties' objections to 4, 5, and 7 are equally meritless. Those interrogatories simply request that the Wayfarer parties identify each defamatory statement you allege, the Sloane parties made concerning any of the Wayfarer parties, identify each of the malicious stories portraying Baldoni as a sexual predator, and identify each of the stories critical of Baldoni, including that Baldoni was a sexual predator ahead of the film's release. Okay. Tellingly, the Wayfarer parties do not, because they cannot, respond. And then footnote 5 here says, strikingly, during the meet and confer, the Wayfarer parties' counsel could not even confirm whether the Wayfarer parties are alleging that Ms. Sloane ever used the words sexual predator or sexual assault in reference to Baldoni, nor would they offer any other clarification as to what the Sloane parties' allegedly defamatory statements are. Interesting. Hey, Teresa, I see a lot more of my mods are in here now. Thanks, guys, for joining. Okay. Once again, during the parties' meet and confer, the Wayfarer parties objected to these interrogatories solely on Local Civil Rule 33.3 grounds. But 4, 5, and 7 seek information of a similar nature contemplated in Local Civil Rule 33.3a. Like the other categories of information specifically delineated, a list of the allegedly defamatory statements and articles should be quite simple to provide and should logically be provided at the outset of the case to guide future discovery and promote judicial economy. At a minimum, 4, 5, and 7 fall within the scope of Rule 33.3b, which permits litigants to serve interrogatories that exceed Rule 33.3a if they are a more practical method of obtaining the information sought than a request for production or a deposition. It would be inefficient and unduly burdensome for the Sloane parties to review every single statement that Ms. Sloane has ever made and then guess which of those statements, if any, that's a bit dramatic, the Wayfarer parties claim is defamatory. Similarly, the Sloane parties need to know which news articles the Wayfarer parties allege are defamatory or otherwise actionable. Given the publicity surrounding this dispute and the number of articles written about it in the past year, it would be impossible to complete discovery into allegedly defamatory articles, including document and deposition subpoenas to the journalists and entities that wrote and published them, without a set list of what is claimed to be defamatory. Simply put, the Sloane parties need a basic roadmap of the claims against them to prepare their defense and target discovery appropriately in response to interrogatory numbers 4, 5, and 7. Is the most efficient means of conveying this information. Okay. 3, the Wayfarer party should answer request for production number 32. So I think we're up to, there's 5 things at issue here. This is the 5th one. And the footnote 6 is, where is that attached? Hang on. Right here, okay. Footnote 6 says, of course, this is why the Wayfarer parties were required to, but did not plead defamation with particularity in the first place. All right. Okay. Number 32 requests documents upon which they intend to rely in drafting a further amended complaint, including but not limited to the documents referenced in their March 6th brief in opposition to Sloane and Vision PR's motion to dismiss. The Wayfarer parties have repeatedly represented, both in their filings and in the press, that they have obtained additional information about the Sloane parties' activities, that they will add to their amended pleading. I don't know that they said that about Sloane specifically. I think it was in a broad sense, but I can kind of see that. Okay. Inexplicably, the Wayfarer parties refuse. I'm sorry. I don't know why I just read that in my head. It was a Severus Snape voice. Inexplicably, the Wayfarer parties refuse to produce the information, even though it is clearly discoverable. All right. If, as the Sloane parties suspect, the Wayfarer parties' representations to the court and the press were lies, all right, then, and they have no additional evidence against the Sloane parties, they should simply admit as much. Okay. And so this is under seal, so we can't see Exhibit A and we can't see Exhibit B. They're both Justin Baldoni's responses and objections. Okay. And then here we have the actual document that we're going to be looking at. Defendant/consolidated plaintiff, Justin Baldoni's responses and objections to consolidated defendant Leslie Sloane's first request for production. Wait. What is this? Oh, we can see Exhibit B. Oh, weird. Okay. Are we supposed to be able to see Exhibit B? I guess they did just ask for Exhibit A to be sealed. Yes. Let's go back to, hang on, let me pull up that letter really quick and double check that. Attachment A to request preliminary seal. Yeah, okay. So they only sealed attachment A. I see. My bad. Okay. Dude, what's your nighttime medicine? I want some. It's well, I think you know the answer to that. All right. Let's see. We'll go back up to the top here. So we're not going to read this word for word. It's a lot of questions. We'll kind of skim through it together. Let's see. Justin Baldoni, by and through his attorneys, hereby objects and responds to the first request for production served by Leslie Sloane. General objections. Responding party generally objects, okay, to for 1 to 33, and I'm guessing there is only 33 on here, but we'll find out. The assertion of similar or additional objections does not waive any of the following general objections. Responding party incorporates by reference the following objections to each of his responses. Okay. 1, they reject the requests that they're seeking documents or information that's not relevant to the claims or defenses, not proportional to the needs of the case. Okay. Like I said, we're going to skim through some of this together. And again, I'm going to post the full document when we're done here. So anything that I skim over that you want to look into more, you can just click the link. I'll put it in the comments as soon as we're done with the stream. Okay. Responding party objects to propounding party's request that to the extent that they seek documents or information outside the possession, custody, or control of responding party. Justin objects to Sloane's requests to the extent they seek the disclosure of information or documents protected by attorney-client privilege, work product doctrine, or any other applicable privilege. Justin objects to Sloane's requests to the extent that they seek information or documents that Justin is under an obligation to any third parties not to disclose. Okay. They're objecting here to producing documents reflecting trade secrets or proprietary business information or documents that would infringe on privacy rights. 7, they're objecting to producing, information or documents that are vague, ambiguous, unreasonably cumulative, or duplicative, are unduly burdensome, or seek information or documents obtainable from other sources which are more convenient, less expensive, or less burdensome. I think these, so these are all pretty standard things, but I've never read one of these through before, so we'll keep going a little bit. Okay. Objects to requests for, things that are burdensome to the extent they seek information or documents that are publicly available, equally accessible to propounding party, or already in propounding party's possession, custody, or control. I mean, that seems like a no-brainer, but okay. A lot of this does. Okay, here they're objecting to the extent they seek the disclosure of information or documents concerning responding parties' trade secrets or other confidential or proprietary business information, or the confidential or proprietary business information of third parties they're obligated to protect. Okay. Here they're objecting to the extent they rely upon or seek legal conclusions or opinions. Okay. Skim over that. Objects to requests as vague and or ambiguous to the extent they include terms the propounding party has not appropriately defined or limited. Okay. Here they're objecting to documents, communications, or information as irrelevant, overbroad, unduly burdensome, and disproportionate to the needs of the case. Okay. Here their responding parties' responses herein are based upon present knowledge information and belief following his diligent search and reasonable inquiry. Discovery and investigation are ongoing, and responding party reserves the right to amend, correct, supplement, or clarify his responses based upon, among other things, further investigation, discovery of additional facts or information, or developments in this action or in related law, particularly in view of propounding party's failure to comply with the local rules. Okay. Responding party provides the following objections and responses without waiving his right to present evidence at trial of any later ascertained facts. Okay. Discovery is ongoing, and responding party, Justin, reserves the right to supplement these responses in accordance with the federal rules of civil procedure. Okay. Okay, so here we're in section 2, responses and specific objections to consolidated defendant Leslie Sloane's first request for production. So here we're going to see what they were requesting and what Justin had to say in response, or why he doesn't want to produce the responses requested. So, hey CJ, not sure, we just got to this part of it, so. All right, number 1, all documents concerning Leslie Sloane. That's broad, or it could be, I guess. Responding party objects to this request on the grounds that it fails to describe with reasonable particularity each item or category of items to be produced. They further object on the grounds that it's overly broad and unduly burdensome, and that it requires Justin to produce all documents concerning Leslie Sloane without limiting the subject matter to the claims or defenses in this action or the relevant time period. Okay. Further objects to the request to the extent it seeks the disclosure of information or documents protected by the attorney-client privilege, work product doctrine, or any other applicable privilege or protection. Okay. All documents concerning Vision PR, so that's going to be pretty much the same there. All documents concerning your allegations in the complaint and amended complaint you filed in docket number 25. Okay. Got it. And this was, I think this was one of the ones that they wanted them to respond to that they would not. So we have 3, 4, 5, and 7 that they're asking them to, they want to compel them to answer. And then 30, I think it was 32. Yeah, 32. Okay. Let's go back here. Sorry, guys, I needed to double back there. Okay. So this was the first one they don't want to answer that they're trying to compel them to answer. Responding party incorporates by reference in his general objections as if fully set forth in response to this request. He objects to this request on the grounds that it fails to describe with reasonable particularity each item or category of items to be produced in violation of the federal rules of civil procedure. Further objects on the grounds that it's overly broad and unduly burdensome. So that's going to be, I think, most of these answers are going to be the same. So the interesting part here is just going to be the questions, I guess, or what they're asking for that they don't want to produce. So we'll just kind of go. But like, I agree that that is like, that opens up a giant kind of floodgate. I feel like there could be so many things that they would have to produce if it's like broad like that. But I've never, like I said, I've never seen one of these before. So maybe I'm wrong, but we'll have to wait and ask the attorneys. Okay. If only Cassidy was here. Okay. Number 4 was another one of the ones they don't want to, produce, that they're being compelled, or they're asking the judge to compel them to produce. All documents concerning allegations of sexually explicit or other inappropriate or unwelcome actions, conduct, or comments made by Baldoni, Heath, or anyone else during the production of the film. Okay. Vague as to allegations of sexually explicit or other inappropriate or unwelcome actions. Okay, so they're saying it's too vague. Got it. Number 5, all documents concerning communications by or involving any Wayfair parties or their agents related to formal or informal complaints or discussions about the work environment on the set of the film by anyone, including the Lively Reynolds parties. Okay. So they're looking for any sort of formal or informal complaints or discussions about like the stuff that was happening on the set that Blake alleges was happening on the set. Now remember that she never filed any formal type of HR complaint or anything like that, but they're asking also for informal complaints, and that could refer to a lot of different things. I don't know, about the work environment on the set of the film by anyone. I mean, that could refer to like, I don't like that the water is room temperature, could it not? If you really want to be that broad about it. That's just my, as a layperson, right? As a layperson, that is my kind of first take is like, well, that could mean just about anything. Okay. Number 6, all documents or communications concerning complaints about Baldoni or Heath in any employment setting at any point in time. Okay, that is also, that could take forever. Okay. Only if there are complaints, like what I'm saying, like assuming that there are complaints, and first of all, complaints about what? And then if we're going from Leslie Sloane's perspective here, which is that she thinks Baldoni and Heath are a couple of like heathens. So she's expecting there to be many complaints. So like that would take forever in any employment setting at any point in time. Like what if one of these guys worked at Burger King once and somebody complained because they were wearing their apron backwards? Like, you know, any point in time, that's kind of, in fact, I would absolutely produce that information just to be funny, but that's just me. I don't know if I'm being too argumentative or not. Because like I said, I've never seen one of these before. So like, you guys are getting my perspective as somebody who's just like a normal average person. Well, I mean, I'm weird, but I mean like intelligence wise and understanding of the legal system wise. And I'm reading this and this is what's going through my mind. So yeah. X lady says, too broad of scope. Yeah. So no Burger King documents, I guess. Request for production number 7. All documents or communications concerning allegations of sexual harassment, sexual assault, and or unwanted sexual contact by Baldoni or Heath at any point in time. Okay. I mean, I feel like that's less broad. So. Okay, number 8. All documents concerning contracts or agreements with any public relations, marketing, publicity firms, or other third-party firms or providers of any social media services, including but not limited to efforts to seed, influence, manipulate, boost, amplify, or engage with social media algorithms, narrative, or virality, as well as the use of bots or inauthentic accounts. Wait. Contracts or agreements with any, okay, firms, okay. Relating to use of bots or inauthentic accounts. I don't know, people who work in like actual PR and work with these types of firms and stuff have come out and said like, no, this is a real strategy. People do this. But to me, it's still funny just like thinking of people behind the scenes. And it's because I'm not an influencer, right? So this stuff doesn't matter to me. I'm thinking about people behind the scenes actually arguing over like using bots on Instagram or something. Yeah, guys, the gummy kicked in. Okay. All right. Whoa, this is a long answer. I don't see anything that's too crazy, though. Number 9. All documents concerning actions taken to harm the Lively Reynolds parties, Sloane or Vision PR, and to damage their public image. Okay. Request number 10. All documents concerning solicitation of individuals or entities to post negative material or comments or reactions, like votes or likes, about the Lively Reynolds parties, whether paid or unpaid, in any online forum, including but not limited to TikTok, Instagram, Facebook, X, formerly Twitter, Reddit, YouTube, or Snapchat. Snapchat? Are these guys Snapchatting people? I mean, like, go dislike Blake Lively's stories? Like, I don't think that's happening. That's really funny, though. Okay. Does anybody else in the chat still have Snapchat? I do, but I mostly send my chins. All right. I'm trying to figure out what else. Like, why is that relevant? I guess it kind of makes sense. Request for production number 11. All documents concerning solicitation, encouragement, creation, seeding, or purchasing of any online, digital, or social media or bot services, including those that generate artificial, inauthentic, and/or machine-generated negative posts or comments or reactions about any of the Lively Reynolds parties, Sloane, or Vision PR. This kind of makes me think of, like, I did a short stream on this not too long ago. Those like bot YouTube channels, those AI channels who are like farming ad revenue by making up fake conflicts between Blake Lively and other celebrities. Like they were doing Meryl Streep, they were doing Margot Robbie, all kinds of stuff. And it kind of makes me think about that. I'm like, well, some of that, and in my opinion, a lot of that is going to be people who are just, like I said, farming for ad revenue. They're exploiting people, but they find like a topic of interest and stuff like that. There's people behind that who are trying to make money. They're not necessarily trying to make one person look bad. You know what I mean? It's just they're seeing, oh, the popular thing right now is to shit on this person. So we're going to make up a bunch of controversies about that person. So people will click on it, they'll comment a lot, and we'll get lots of money. And they don't care if it's real or not. So that's what that makes me think of. All that to say that a lot of those channels and stuff like that, I don't think it's a PR thing. I think it's literally just people trying to scam for money. So we should ask Ashley about that. Okay. Request for production number 12. All documents concerning solicitation, encouragement, creation, or purchase of any online, digital, or social media bot services. Oh my God, so many bot questions, including those that generate AI, machine-generated positive posts or comments or reactions about any Wayfair party. I'm not a bot, I promise. 13, all documents concerning solicitation, encouragement, creation, or purchase of any online, digital, or social media or bot services, including those that engage with audiences, perform account takedowns, start threads of theories. Threads of theories? There are bots doing that? Create social fan engagements and or attempt to influence public narrative in any other way. Alrighty then. They are obsessed with bots. It sure seems like the bot thing is like something that I thought it was a joke for a long time, right? So I didn't think it was as serious as it apparently is. Like I didn't know there were PR firms employing bot armies and shit like that. So the whole thing is, I don't know, because I really do think that a lot of it's organic, right? But I had no idea until recently that this was even a thing that people actually did. So, yeah. Froggy, thank you for becoming a YouTube member. I appreciate you. I have something members only coming out this week. I was supposed to post it yesterday, but something came up. So I will be doing that very soon. Tanya Vincent, thank you for the 279. The mic drop when searched and nothing comes back. Wait, what? Oh, I get it. Okay. You mean about the complaints and stuff? All right. Number 13. Got that. Request for production number 14. All documents concerning communication with any media outlet of any kind. God, that could take for fucking ever. They were promoting a film. Encouraging it to publish a negative post, comment, reaction, or article about any of the Lively Reynolds parties, Sloane, or Vision PR Inc. Well then. Request for production number 15. All documents concerning communication with any media outlet of any kind, encouraging it to alter or not publish a positive post, comment, reaction, or article about any of the Wayfair parties. Huh. Well, I guess if they're just, when they're saying media outlets, are we talking about just like magazines and news channels and shit like that? Or like TMZ type websites? Or are we talking about everybody? Like any communications with YouTubers or TikTokers or anything like that? I don't know. I don't totally get that. But I guess they are only asking for specific actions, like encouraging it to alter or not publish a positive post. Okay. And the last one was a similar request. And they're still saying, it's vague. So we don't want to do that. Okay. Request 16. All documents concerning communications with any current or former cast, crew, colleague, employee, agent, or other associate of any of the Lively Reynolds parties or the Sloane parties. Okay. including but not limited to communications designed to gather negative intelligence on any of the Lively Reynolds parties, Sloane, or Vision PR. 17. All documents concerning any and all articles or copy of any kind drafted about any of the Lively Reynolds parties, Sloane, or Vision PR to be used in the media, on social media, or the internet. Does that include diary entries? All right, 18. All documents concerning any plan, program, strategy, or campaign by Melissa Nathan, any employee of TAG, or any vendor, contractor, or other third-party entity working in cooperation with the same, or any other Wayfair party to disparage any of the Lively Reynolds parties, Sloane, or Vision PR, or harm their public image. 19. All documents concerning any attempt to hide or divert attention from any Wayfair party's inappropriate, unwelcome, and harassing activity on the set of or related to the film. 20. All documents concerning formal or informal allegations or complaints about a hostile work environment or other inappropriate or unlawful conduct on the set of the film. That's kind of similar to the one we read above where I was talking about the room temperature water and how people could complain about that. And does that count? But this feels more specific. I don't know, but it feels like the same question, just more specific. So I don't know, whatever. Somebody says, Sloane is crazy. Of course they're not giving her all this. The point of the lawsuit is she's supposed to prove that they did this stuff. Yeah. Let's see. 21. Concerning any other real, alleged, or reported feud. Okay, so they want anything that's relating to the reported feud between Lively Reynolds and the Wayfair parties regarding the filming, editing, production, marketability, publicity, or distribution of the film. Okay. Any other real, alleged, or reported feud or dispute or disagreement. That, again, that could take for fucking ever. I mean, whoa. 22. All documents concerning all documents and records of any kind, reflecting payments to anyone for services of any kind related to the Lively Reynolds parties, Sloane, or Vision PR, including but not limited to in support of any negative media or social media campaign against the Lively Reynolds parties, Sloane, or Vision PR, or any of them. Any of them? I don't know why you would add that, but okay. See, 23. All documents and communications concerning efforts to conceal strategies or actions taken to harm Lively, Reynolds, and Sloane, and to damage their public image. 24. All documents and communications concerning efforts to conceal strategies or actions taken to influence public perception regarding the Lively Reynolds parties, Baldoni, or Heath. Okay. 25. All documents and communications concerning Baldoni discussing his porn addiction with Lively. Really? Jesus Christ. I'm going to pause here for a second and talk about this. People harp on this porn addiction thing a lot, right? People are like, I can't believe you're supporting some growth porn addicted dude. First of all, if somebody overcomes an addiction and they use that experience to, try to help other people overcome their problems, even if we consider that problem to be disgusting, like it was a porn addiction, I mean, still, it's like somebody's trying to better themselves. They're trying to do better. So it bothers me a lot that this guy's like, I had an addiction. It was unhealthy for me, and I overcame it, and I worked really hard as hell to do better. And then people are just putting him down as a disgusting porn addict. Because I feel like it's really hard to be on the receiving end of that, I'm sure, and to feel like, well, then what's the fucking point? If people are always going to look at me and put me down as like a disgusting person, if I'm always going to be viewed as this horrible, awful guy, then what's the point? Surely there are a lot of people out there who have overcome addiction who feel like that. And so when I see people talk about celebrities or politicians or anybody really, and they're like, well, he was addicted to XYZ, unless it's like something totally unforgivable, like relating to kids or something like that, because that's a no. You don't come back from that. You leave me alone. But anything else, even if it is a porn addiction, Like, I'm not going to judge them for that. Like, I might judge them because I don't like their views on other things. I might judge them because they're not a great person, but it's not going to be because they were addicted to something. It's not going to be because they overcame an addiction of any kind. Like, I just hate that. I really do. So, anyways, that's my soapbox. Give me 1 sec. 1 sec. All right. Sorry about that. Froggy, thank you for the $2 super sticker. I appreciate you. I knew that was coming. Sorry. Working, Froggy says working on your shelf should be okay. I agree. Okay. What triggered you? My sneezing? Okay. Request 25. All documents and communications concerning Baldoni discussing his porn addiction with Lively. Okay. It is vague as to discussing his porn addiction. So there's nothing it's pretty much the same answer all throughout. Okay. 26. Communications concerning Baldoni entering Lively's trailer without her consent. Don't think that happened. There's evidence that she did invite him in there, but okay. I suppose they're fishing for some evidence now, but whatever. They're supposed to do that, I suppose. All documents and communications concerning Baldoni improvising kissing or sexual scenes in the film. And here's where a lot of people disagree between the two camps is him, wanting to add certain scenes and stuff like that. It's like a romance film. He's supposed to make, he's supposed to make it a good sex scene. So but then they're saying that the other camp is saying, well, he was improvising. It wasn't scripted, that kind of stuff. But if he's working on it, he's maybe we should do this or this. And he's bringing up ideas and bringing up different ways to act it out. That's not a problem. It's his film. That's what he's supposed to be doing. So 28, all documents and communications concerning Baldoni having sexual contact with any third party without her consent. What the fuck is that about? What are you talking about? Literally, what are you talking about? I feel like you just put that in there to be a dick. All right. Request for production number 29. Any telephone, video, or voice recordings of Sloane or Vision PR, Inc. Well, that tracks. She does strike me as somebody who likes to listen to herself talk. So, okay. 30. All documents you receive from third parties in response to subpoenas you served or other legal processes you initiated concerning the Lively Reynolds parties, the film, or any disputed issue in this case. Oh, third parties. It took me a second to get that. I was like, why the fuck would they need to produce that to you? And never mind. It makes sense now. 31. Documents sufficient to show the identities and locations of the participants included in text messages appearing in paragraph 193 of the amended complaint filed on January 31st. I'm trying to remember what that was. Paragraph 193. I'll have to look that up. Okay, and 32 is another one of the ones that they're compelling, or they want the judge to compel Justin and Wayfair to answer. This is a long one. My God. Oh, no, that's because I skipped to the response. Okay, the request is all documents upon which you intend to rely in drafting a further amended complaint, including but not limited to the documents referenced in your March 6th brief in opposition to Sloane and Vision PR's motion to dismiss. Okay. And 33, all documents upon which you intend to rely to support your case and affirmative defenses. All right. April 14th. Okay, so I guess they've had this for a while. Well, no, that makes sense that they've had it for a while because now they're arguing about not wanting to answer or whatever. Exhibit C is that complaint against the New York Times filed by Justin and Wayfair in California. And so we don't need to go through that because we've already seen that. So, yeah. All right, let me see. What are you guys talking about over here? Per those 17 points, Blake had the power to review and approve script changes, including sex scenes. She also had access to the intimacy coordinator and a body double. Yeah, get out, Leslie. Okay. AV Club is weirdly very anti-Baldoni, not pro Blake, but not very. What's AV Club? I don't know what AV Club is, yo. No, I'm reading some of your comments before I sign off because we're done with the filing here. If I had known this was coming out tonight, I would not have taken a gummy because I'm going to be useless in 10 minutes. So I can't just sit here talking to you guys about something else because I will get lost in my own house. Snarky millennial pseudo-feminist humor used to be part of The Onion. Huh. Yeah, I've never heard of it, but it doesn't sound like something that was really up my alley. So I'm going to pass on that. All right. Thanks, everybody. Good to see you guys here. I appreciate you joining. Don't forget to like the video. It helps my channel out with reaching more people. So I appreciate that. I'm going to sign off for tonight. I think I'm all done for tonight. Yeah, that'll be good. And I'll see you guys again tomorrow. So bye.